So the Supreme Court's recent 8-1 decision in a Second Amendment case is now being used as support in the Texas dispute between the Biden administration over the border and its security. Now, before we jump into this video, I want to thank one of the new sponsors of the channel, which is Patriot Mobile. For 10 years, Patriot Mobile has been the only company in America, the only wireless provider that has Christian conservative values. Patriot Mobile offers dependable nationwide coverage, giving you the ability to access all 3 major networks. That means that the same coverage you would get from those companies is the exact same that you would get from Patriot Mobile. And you can also then support a company that has the same values as you, which is pro freedom of speech, pro 2A, and pro freedom. I first met Patriot Mobile over at SHOT Show. I met their whole marketing team. I got to have conversations with them, and they seemed like a really cool company. And they were actually sponsoring, SHOT Show, which is a big deal. And also, they are 100% based in the US, which means that if you need to call customer service, they're all here in the US, and I believe most of their team is actually in Texas. So I recommend that you guys check out Patriot Mobile if you're interested. You can go to patriotmobile.com/scholar, or you can call 972-PATRIOT. And if you use the code SCHOLAR, you can get a free activation fee. So again, really excited about this sponsor, a really cool company. They have the same values as us. And if you guys are interested, again, check out those links. As I mentioned in the intro, we need to talk about a new decision recently issued by the Supreme Court, which is now being used to support Texas in their dispute over the border. The state of Texas is using this recent Second Amendment decision to support their right to self-defense and argue that they have the right to protect the border. At the end of the Supreme Court's last term, the Supreme Court issued an 8-1 decision in a case called U.S. versus Rahimi. This was a case that dealt primarily with the Second Amendment, but now it's being used to actually support the state of Texas in this lawsuit. That decision focused on if a section of federal law which restricts the possession of firearms to people who are subject to domestic violence restraining orders, essentially whether or not that was a violation of the Second Amendment. We've talked about that decision a lot, but very interestingly, now that Rahimi case is being used by the state of Texas in their lawsuit to argue that the Biden administration should not have won the lower court review of this case, they should not have been granted a preliminary injunction, and that essentially they did not meet the burden to show that there was a facial challenge to this law here in SB4, this law in Texas, and that essentially Rahimi can be used to show that the state of Texas should have won at the lower court level. Now, we need to do some background on this case, also the Rahimi case, so that you guys understand what exactly is going on with this lawsuit, what is going on with this dispute over the border, and how Rahimi is now being utilized in this case. So for reference, Texas SB4 effectively makes it a crime for an individual to violate federal law by crossing into the state of Texas at any location other than a lawful point of entry. This is a law that the state of Texas passed. It also makes it a further crime for you to illegally re-enter if you've already been denied admission into the United States. And then finally, it allows judges in the state of Texas to issue orders requiring that those individuals have to go back where they came from. Now, this law that was passed in the state of Texas was challenged by the Biden administration. A district court on review of this case issued a preliminary injunction which prevents the state of Texas from enforcing all of SB4. So it put a block on the entirety of SB4. The lower court found that SB4 was facially invalid. So there's a difference between as-applied challenges, which are more specific to an individual, saying that a law is invalid or unconstitutional as applied to one specific individual. Here, what happened is the Biden administration and then also individual plaintiffs brought a facial challenge against all of SB4. They won at the lower court level, and then the lower court put a universal block on all aspects of SB4. Now, in reaction to that, Texas then appealed that preliminary injunction up to the Fifth Circuit. And in response, the Fifth Circuit issued an administrative stay on that lower court universal order. So they put a block on a block. Now, there was also a dispute where then all these cases, because there was multiple cases dealing with SB4, all of those were consolidated at the Fifth Circuit level. And then also those consolidated plaintiffs decided to seek emergency intervention from the Supreme Court. They wanted a removal of all those blocks. And ultimately, on review, the Supreme Court decided not to step in early. They decided not to remove what happened at the Fifth Circuit level. They decided not to remove the Fifth Circuit's administrative stay. Essentially, they sided with the state of Texas. Now, once that happened, though, that same day, a 3-judge panel in the Fifth Circuit who was assigned all these cases decided to then remove the administrative stay on their own. So on their own, they decided to remove that block, and effectively at that point, they were siding with the Biden administration. But this case has moved forward fairly fast. Just a few days after that removal of the block, the Fifth Circuit 3-judge panel held oral arguments on whether or not they would grant a preliminary injunction in favor of the Biden administration, which would again more permanently close the door on SB 4's implementation, or they would decide if they wanted to actually rule in favor of the state of Texas. Now, during those arguments, there were some concerns about if the United States government could in fact seek this type of universal equitable relief against the state of Texas. There was a lot of dispute during those hearings, especially from one of the dissenting judges, Judge Oldham, who agreed with the state of Texas that the government here, the United States government, cannot file this type of lawsuit, and they cannot try to get this type of universal block on this type of law. Well, now the state of Texas has submitted the United States versus Rahimi case, that Second Amendment case, as authority to show that the facial challenge brought by the Biden administration, in fact, is invalid, should not have been allowed, and that the Fifth Circuit should, in fact, uphold SB 4 and allow the state of Texas to protect its own borders. So the letter submitted to the Fifth Circuit by the state of Texas states that counsel provides notice under the Rule 28J, which is a 28J letter, of the Supreme Court's decision in the United States versus Rahimi case, which further demonstrates that the district court erred by facially enjoining SB 4. In Rahimi, the court rejected a facial challenge to a statute prohibiting individuals subject to domestic violence restraining orders from possessing firearms. The court explained that a facial challenge, the most difficult challenge to mount successfully, requires a defendant to establish that no set of circumstances exists under which the act would be valid. Said differently, to prevail, the government need only to demonstrate that the challenged law is constitutional in some of its applications. The Supreme Court reversed a panel of this court because it did not correctly apply our precedents governing facial challenges. Rather than focusing on the circumstances in which the challenge statute was most likely to be constitutional, the panel here focused on hypothetical scenarios where the provisions might raise constitutional concerns. This court thus erred by slaying a straw man. Instead, when legislation and the Constitution brush up against each other, a court's task is to seek harmony, not to manufacture conflict. Indeed, federal courts assessing a facial challenge lack authority under Article 3 to decide whether a challenge statute is always lawfully applied, rather than whether it has any lawful scope. This court should not repeat the district court's error on appeal. Plaintiffs have failed to show that the federal law preempts SB 4 at all, let alone in every application. As Texas has explained, SB 4 mirrors and supplements federal statutes. It does not conflict with them. Regardless, because the Constitution trumps statutory law, SB 4 can be applied pursuant to Texas Self-Defense Authority, which at a minimum covers armed incursions by violent transnational cartels and does not require the consent of Congress. Because SB 4 can constitutionally be applied in at least some of its applications, Rahimi dooms plaintiffs' facial challenges. So this is a very interesting and important development in this whole Texas border dispute and this whole lawsuit. I definitely didn't have on my bingo card that Rahimi, this Second Amendment case, would be used by the state of Texas to attack what is going on right now, to try to protect SB 4. Rahimi did clarify when facial challenges should prevail and essentially when they should in fact fail. For Texas SB 4 to be found facially invalid under the Constitution, the Biden administration and the plaintiffs here would need to show that there is not a single constitutional or legal application of SB 4. Now, that's a very high bar to meet, and that's what Texas is arguing here, and they're arguing that the Biden administration has not met that burden. So again, very interesting that you have the Second Amendment Rahimi case now being used in this Texas border dispute case, using the whole facial challenge analysis in Rahimi to support Texas. It's going to be very interesting to see how this develops going forward. And of course, if anything else changes, I will let you guys know. But if you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and also it signals to the algorithm that you guys see value in these videos and this type of two-way news, and then it pushes it out to more people. And then also I want to mention that we have a newsletter available. If you would like to sign up, links will be down below, and we're going to be doing some giveaways and stuff like that over on the newsletter. So again, if you're interested, you can find links down below. But regardless, thank you all so much for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.